Researches and studies found out that domestic violence is one of the most common forms of violence experienced by women globally. Hence, in the Philippines, violence against women appears to be one of the country's pervasive social problems. According to the 2017 National Demographic and Health Survey conducted by the Philippine Statistic Authority, 1 in 4 Filipino women aged 15 to 49 has experienced physical, emotional, or sexual violence by their husband or other men with intimate relationship. The Philippine populations, as projected this November 2022, reached to 113,050,866, wherein 49.8% are women population, 56,299,331, meaning to say that around 14 million estimated as VOW victim. So it is indeed an alarming that despite of efforts of the government and other civil society organization, VOW still persists. Gender-based violence was attributed by the dictates of the societal norm and tradition thinking that men are the leaders, pursuers, and providers, and they take the dominant role in the society, as they think women are the nurturers. These perceptions lead men to gain power over women. Hence, vow became a form of men's expressions of control over women to retain the power. It's been disappointing that reports one VOWSI cases could not be exactly determined, particularly the extent of the violence, since majority of the Filipino women preferred to remain in their culture of silence. They are ashamed to divulge it publicly, to preserve their good reputations in the society. Moreover, they do not have the courage to file their complaints as they lack faith in achieving justice. Facing with this enormous challenge, a special law was enacted, Republic Act 9262, known as Anti-Violence Against Women and Their Children Act of 2004, which penalizes as public crimes certain acts of violence against women and their children. What is violence against women and their children? Vows is any act or a series of acts committed against victim which result or is likely to result in physical, sexual, psychological form or suffering or economic abuse, including threats of such act, battering, assault, coercion, harassment, or arbitrary deprivations of liberty. Who are the children protected under the law? Children means the abused women children, boy or girl below 18 years old, whether legitimate or illegitimate, and also includes other children who live with the women and under her care. Moreover, person aged 18 years old and beyond who doesn't have the ability to decide for herself or himself because of an emotional, physical, and mental illness can make full use of the law. Who are the possible offender or perpetrator? The following can be held liable for violations of RA 9262. Husband, former husband, boyfriend, girlfriend, ex-boyfriend, ex-girlfriend, one with whom the woman has a common child, one with whom the woman has had sexual or dating relationship. Just to elaborate, the meaning of dating relationship refers to a situation wherein the parties live as husband and wife without the benefit of marriage. Where can VOWSI be committed? Violence against women and their children can be committed within their dwelling, abode, or any place outside home. What are the forms of gender-based violence in VOWSI? VOWSI can be described in the following forms. Obviously, seen are the number 1, physical violence, which refers to acts that include bodily or physical harm to the women or child, either inflicting or threatening to inflict physical harm on oneself for the purpose of controlling her action or decision. Example are beating, slapping, pinching, choking, kicking, shoving, beating, burning, killing on the use of objects or weapon. Number 2, psychological violence. These acts or omissions that cause mental or emotional anguish, suffering, and psychological distress may be committed in the following manners: intimidation, harassment, stalking, damage to property, public ridicule or humiliations, repeated verbal abuse, marital infidelity, causing or allowing the victim to witness the physical, sexual, or psychological abuse of a member of the family to which the victim belongs, causing or allowing the victim to witness pornography in any form, causing or allowing the victim to witness abusive injury to pets, unlawful or unwanted deprivations of the right to custody and or visitations of common children. Number 3, economic abuse. These are the acts that make a woman financially dependent upon her abuser but not limited to the following: withdrawal of financial support or preventing the victim from engaging in any legitimate profession, occupation, business, or activity, except in cases wherein either spouse, partner, objects on valid, serious, and moral grounds as defined in Article 72 of the Family Code. Deprivations or threat of deprivations of financial resources and the rights to the use of enjoyment of the conjugal, community, or property owned in common. Destroying household property. Controlling the victim's own money or properties or solely controlling the conjugal money or properties. Number 4, sexual abuse. This refers to act which is sexual in nature committed against a woman or her child. This includes but not limited to the following: rape, sexual harassment, act of lasciviousness, threatening a woman or child as a sex object, making, demeaning, and sexually suggestive remarks, physical attacking the sexual parts of the victim's body, forcing the woman or her child to watch obscene publications, and forcing the woman or her child to do indecent act or make films thereof, forcing the wife and mistress, lover, to live in the conjugal home or sleep together in the same room with the abuser, causing or attempting to cause the victim to engage in any sexual activity by force, threat of force, physical or other harm, or threat of physical or other harm of coercion, prostituting the woman or her child. Secure a protection order to stop, prevent, and end VAUSI. What is the purpose of the relief granted under a protection order? The relief granted under a protection should serve the purpose of safeguarding the victim from further harm, minimizing and disruptions in the victim's family daily life, and facilitating the opportunity and ability of the victim to independently regain control over her life. What are the protection order that may be issued under Republic Act 9262? The following protection order may be used accordingly. Number 1 is the Barangay Protection Order or BPO, issued by the punong barangay or in his or her absence any available barangay kagawad. It is effective within 15 days. Number 2 is the Temporary Protection Order or TPO, issued by the court and is effective within 30 days. Number 3, Permanent Protection Order or PPO issued by the court after notice and hearing. Since RA 9262 is a public crime, therefore, any citizen who has personal knowledge of the crime can file a criminal complaint. Who may file petition for protection order? A petition for protection order may be filed by any of the following: victim or offended party, parents or guardians of the offended party, ascendant, descendant, or collateral relatives within fourth civil degree of consanguinity or affinity, officers or social workers of the DSWD or social workers of local government unit or LGUs, police officer, preferably those in charge of Women and Children's Protection Desk or WCPD, punong barangay or barangay kagawad, lawyer, counselor, therapist, or healthcare provider of the petitioner, at least 2 concerned responsible citizens of the city or municipality where the violence against women and their children occurred and who have personal knowledge of the offense committed. How to apply a protection order? The application for a protection order must be in writing, signed, and verified under the oath by the victim. A standard application form written in English with translations to the major local languages shall contain, among others, the following information: names and addresses of petitioner and respondent, descriptions of relationship between petitioner and respondent, a statement of the circumstances of the abuse, descriptions of the relief requested by petitioner, request for a counsel and reason for such, request for a waiver of application fees until hearing, and in attestations that there is no pending application for a protection order in another court. What if the applications of the protection order is not the victim? If the applicant is not the victim, the application must be accompanied by an affidavit of the applicant attesting to: number 1, the circumstances of the abuse suffered by the victim, and number 2, the circumstances of consent given by the victim for filing of application, when disclosures of the address of the victim will pose danger to her life. It shall be so stated in the applications. Penalties for committing VAUSI. What are the penalties imposed for the crime of VAUSI? Section 6, RA 9262 provides the following: penalties the crime of violence against women and their children under Section 5 hereof shall be punished according to the following rules: acts failing under Section 5, constituting attempted, frustrated, and consummated parricide or murder or homicide shall be punished in accordance with the provisions of the revised penal code. If this act resulted in mutilation, it shall be punishable in accordance with the revised penal code. Those constituting serious physical injuries shall have the penalty of prison mayor or 6 years and 1 day to 12 years. Those constituting less serious physical injuries shall be punished by prison correctional or 6 months and 1 day to 6 years, and those constituting slight physical injuries shall be punished by arresto mayor or 1 month and 1 day to 6 months. What is the fine imposed on the offender of VAUSI? In addition to imprisonment, the perpetrator shall be pay a fine in the amount not less than 100,000 but not more than 300,000 pesos. Undergo mandatory psychological counseling or psychiatric treatment and shall report compliance to the court. Section 44 or RA 9262 citing prohibited acts confidentiality rule under the law. All records pertaining to cases of vowsy, including those in barangay, shall be confidential, and all public officers and employees and public-private clinics or hospital shall respect the right to privacy of the victim. Whoever publishes or causes to be published in any formal the name, address, telephone number, school, business address, employer, or other identifying information of a victim or an immediate family member without the latter consent shall be liable to the contempt power of the court. What is the penalty imposed? The violations of confidentiality rule. Any person who violates confidentiality of vowsy cases shall suffer the penalty of 1 year imprisonment and a fine of not more than 500,000 pesos. Moving forward, the government provide the vowsy victims the opportunity to move forward from their respective dismaying experiences towards a positive, meaningful life and productive future. These are the programs and services for the prevention, eliminations, and rehabilitations of vowsy. Number one is the institutionalizations and establishment of crisis center being managed by the DSWD and other private institution initiatives providing a recovery and rehabilitation program. Number two, support system, collaborative effort for legal, medical, psychological counseling, educational support, and livelihood assistance by DSWD, VOH, VOJ, and LGUs and other NGOs. Number three, sustain educational and training in gender-based violence. Number four, intensify campaign to end vowsy. Number five, monitor the establishment of Barangay Vowsy Desk Office and their functionality through the DILG supervisions. And number six, creations of functions and interagency council or vowsy at the national and local level.